Hello everyone and welcome back to my channel. We're going to be doing a quick deep dive on the Guardian that has Wendy Williams in her conservatorship. As we know now, her name is Sabrina Morrisey. Sabrina Morrisey has her own private law practice, Morrisey and Morrisey LLP. And in 2024, the U.S. Sun did a story on a particular case that Morrisey was involved in, herself and about 10 other defendants in a lawsuit. According to the Sun, we're going to go ahead and read this. Morrisey and other attorneys were accused in the suit of conspiring to perpetuate a baseless guardianship against an individual, Jose Verdugo, in New York, who had won $5.5 million in a personal injury claim. The plaintiff in the case, attorney Michael Flomenhaft of the Flomenhaft Law Firm, represented Verdugo after he sustained head and back injuries from a construction accident. The case was opened in November of 2022, and in August of 2023, or just under a year, the plaintiff filed they discontinued the above entitled action without prejudice and without cost to either party, as the other, which means Flomenhaft, is allowed to refile charges, alter the claim, or bring the case to another court, depending on the statute of limitations. Flomenhaft claimed that the trouble started around 2009 when a former associate of his, Herbert Rodriguez Esquire, at Schwartz, Goldstone, Capsey and Cates LLP, contacted his client. The court documents allege that Rodriguez misrepresented Verdugo about Flomenhaft's handling of the case and told him and his wife, who desperately needed the award money, that his case could not be finalized unless Verdugo consented to an MHL Article 81 guardianship that Verdugo did not want or need. I'm going to repeat that. The court documents alleged that Rodriguez misrepresented Verdugo about Flomenhaft's handling of his case and told him and his wife, who desperately needed the award money, that his case could not be finalized unless Verdugo consented to an MHL Article 1 guardianship that Verdugo did not want or need. Remember that Article 81 guardianship. We're going to revisit that. That's where Wendy's guardian, who was criticized by the Star's family in the docuseries by Lifetime that aired this was when it previously aired, allegedly became involved in the dispute. Rodriguez and his firm initially partnered and conspired with Sabrina Morrisey, Esquire, of M&M, to impose on Verdugo an MHL, or Mental Hygiene Law, Article 81 guardianship, the court document states. Under the guise of protecting and vindicating Verdugo, they jointly pursued a dual litigation strategy aimed at getting rid of Flomenhaft and allegedly reaping Morrisey and Morrisey's substantial court-awarded fees as guardian counsel through litigation, maligning Flomenhaft legally and ethically. The suit claims that Wendy's conservator became guardian of Verdugo on January 19, 2010, and continued to October 7, 2015, so just over 5 years. The complaint, or the suit, goes on to claim that Morrisey and the form SGCK, empowered by both the confidence and their fee applications, would be judicially rubber stamped, and the consistent judicial resistance to affording Verdugo an opportunity to demonstrate his capacity under the New York mental hygiene law, and thus the invalidity of the guardianship, Defendants have been untrammeled in their scheme. We're going to move on. Now, defendants have conspired to perpetuate a baseless guardianship. Now, the defendants in this case, again, is Morrisey and 10 other attorneys. Conspired to perpetuate a baseless guardianship over a ward named Jose Verdugo under the guise of protecting Verdugo's best interest, the lawsuit alleged. For more than a decade, defendants have imprisoned Verdugo in a humiliating and oppressive guardianship by manipulating and serially deceiving him, as well as New York Supreme Court and the Appellate Division. It continued. The complaint, which details over a decade of litigation related to the conservatorship, including filings pertaining to the guardianship of the ward, various other court actions on his supposed behalf, accused Wendy's conservator and other guardianship attorneys of falsely perpetuating a baseless guardianship to silence and legally incapacitated Verdugo from acting on his own behalf. The plaintiff alleged that the litigation, which in part drained Verdugo's settlement with excessive attorney fees, all stemmed from a $5,000 discrepancy in 2007. Okay, we're going to move on. Now, the case estimated that after Verdugo's initial award, he had $2.47 million left after attorney's fees, cases expenses, and discharge of liens. But in the following years, the defendants allegedly pursued litigation without their client's consent to the tune of at least another $1.1 million. The claims were dismissed voluntarily before Morrisey or any other defendants filed an answer responding to the specific allegations. Morrisey was also contacted for comment in connection with this story. The suit alleged that the plaintiffs thwarted for years Verdugo's rightful emancipation from his guardianship. Again, the suit alleged that the plaintiffs thwarted for years Verdugo's rightful emancipation from his guardianship, and that they strenuously sought to insulate Verdugo from discovering that the guardianship was being exploited for their own personal financial gain. Okay, now moving on. All right. The case claims that Verdugo's daughter had tried to get her father out of the conservatorship in 2021. The case alleged that Verdugo's medical records confirmed his capacity for more than a decade. The steadfast refusal of the guardians and the court to arrange for a capacity hearing to determine the necessity of the guardianship ultimately required Fatima, who is Verdugo's daughter, to file an Article 78 proceeding order. This hearing, the filing stated. In the suit, multiple doctors gave attestations to Verdugo's cognitive abilities, and they said he was not deficient. Again, in the suit, multiple doctors gave attestations to Verdugo's cognitive abilities, and they said he was not deficient. One of the doctors wrote, he is not found to be incompetent to a degree that he needs a guardian from a neuropsychiatric point of view. Now, Flomenhaft's complaint alleged that in 2016, Wendy's conservator, this is Morrisey, pursued additional litigation against Flomenhaft, to which her ward entered an affidavit. Her client, Verdugo, allegedly wrote at the time, I do not support this lawsuit against Mr. Flomenhaft and his law firm. I got the Peachtree money and deposited into my bank account. I gave Mr. Flomenhaft permission to use the rest of my money how he saw fit to pay for my case expenses. I am angry that I am being used. The guardian is using me to sue Mr. Flomenhaft without my permission, and it has and continues to cost me hundreds of thousands of dollars in attorney fees. I understand that Mr. Fillman have tried to get the case dismissed, but the attorney from the law firm for my previous guardian, Michael Weiner, swore that I have been insane, since 2003, even though I have never met Mr. Weiner. I understand that Mr. Rodriguez and his current law firm also supported that lie. I am a functioning, intelligent, and independent person employed by different companies and different jobs. I am certainly not insane, his statement concluded. Flomenhalf's latest lawsuit also accused Morrisey and the other defendants of racketeering. As set forth in the preceding paragraphs, defendants and each of them have engaged in and contributed to a chronic pattern of collusion and conduct, entailing both deceit and attempted deceit upon plaintiffs, Verdugo, and the guardians themselves. By reason of the foregoing, plaintiffs have been substantially harmed by sustaining attorney fees and expenses, massive loss of professional time, reputational harm, and delay in receiving apportioned attorney fees and investment loss and interest. The suit also claims the defendants violated civil rights law. In violation of Civil Rights Law 70, these defendants prosecuted each of the matters in the consolidation purportedly on Verdugo's behalf without Verdugo's authorization when he possessed capacity and the right to be free of guardianship control, and thus entitled to make his own litigation decisions. The total sum of punitive damages being sought from all of the defendants was $30 million. Okay, moving on. Now, remember I said we would revisit the whole Article 81. Here it is. Article 81, guardianship of an incapacitated person. In a case involving a guardianship of an incapacitated person, also known as an Article 81 case, a judge must decide whether a person is incapacitated and if they need to have a guardian appointed. A person is incapacitated if they are unable to care for their own property and or personal needs, and 2, likely to suffer harm because they cannot understand the consequences of not being able to care for their property and or personal needs. At the beginning of the case, this person is called an alleged incapacitated person, or AIP, because their inability to care for their needs is simply an allegation or someone's opinion. To obtain an Article 81 guardian, a person over the age of 18 or entity must first file a case in court and prove that a guardian is necessary. The person or entity that files for the appointment of an Article 81 guardian is called a petitioner. Typically, the petitioner is the alleged incapacitated person's family member or qualified agency. If a judge decides that a person is incapacitated, the proposed Article 81 guardian must complete a training and be approved by the court before they can be officially appointed. If there is no family member willing and able to become that person's Article 81 guardian, the judge can appoint a previously trained person to take on this responsibility. Another option is to appoint a social service agency that specifically provides this type of service. Again, if there is no family member willing and able to become that person's Article 81 guardian, the judge can appoint a previously trained person to take on this responsibility. Another option is to appoint a social service agency that specifically provides this type of service. Now, here's something important to note. Asking the court to appoint an Article 81 guardian to make decisions for another person is a serious matter. Before a judge can appoint an Article 81 guardian, the judge must hold a hearing and listen to testimony and evidence. If a judge decides to appoint an Article 81 guardian, the judge will specify what decisions a guardian can make and what decisions the person with the incapacity can make. based on the needs of that person. In New York State, Article 81 guardianship cases are heard in the Supreme Court or county court and filed under Article 81 of the Mental Hygiene Law. So this is how Sabrina Morrisey was able to come in. This is what she does. This is what her particular firm does. It is a solo practice. Let's look at that. So with the previous case that she was a part of, listed as a defendant alongside 9 other attorneys, I should say, 10 including her. This is what she does. This is what her firm does, her solo practice does. You go to Morrisey and MorriseyLLP.com. It says Sabrina E. Morrisey's primary focus is estate planning, administration, and litigation, and guardianships. Passionate about representing elderly clients and protecting them from fraud and abuse, Sabrina appears regularly on their behalf in the New York State's courts, helping them to obtain appropriate support in the home, safeguard their assets, and plan for the future. Sabrina advocates for vulnerable New Yorkers and their families as they struggle to provide appropriate care. Sabrina advocates for vulnerable New Yorkers and their families as they struggle to provide appropriate care. She is committed to making complex issues, including insurance, Medicaid, Medicare, easy to understand and implement. Sabrina has also served many times as an Article 81 guardian. So not only does she professionally as an attorney focus on estate planning, which we know what estate planning is, right? When people have massive amounts of properties, monies, any type of it's really just assets. Let's just say that. Estate planning, administration, and litigation, and guardianships. That's money within itself. And then she lines herself. She also is an Article 81 guardian. So it's like a twofold practice, right? So Wendy Williams is the perfect case. She's rich. She has all of these assets. There's the estate planning portion, administration, litigation. We know Wells Fargo at one point locked Wendy out of her accounts, said her spending habits were out of the norm, what have you. Somehow, and again, Sabrina Morrisey has served several times as an Article 81. This case comes up. Somehow she is notified about it. She becomes the Article 81 guardian. Those are just the facts. The allegations from the previous case. You can put it together from there. This is Sabrina E. Morrisey. Professional history as we have it. Not all of it, but what we have. The guardian conservator to Wendy Williams. Don't forget to like, share, and subscribe. Thanks for watching.